Conducting Discovery When You're Sued for Debt, Part 2. Brought to you by Kenneth Chabert at YourLegalLegUp.com. Your advantage if you're being sued by debt collectors. The first step in conducting discovery is to determine what you can and should be pursuing. This is a matter of legal research, and there are some general guidelines. First, you'll want to know the elements, that is, parts of the plaintiff's claims. In plain English, that is, you want to know what the debt collector needs to prove in order to win its case against you. Remember that if it brings its claim for money, even the same money under different theories, you'll have to beat each claim or count separately. But that's not as hard as it may sound. Any information related to what the debt collector has to prove is fair game for discovery. Second, if you have any affirmative defenses, you need to know the elements of your defenses, the parts of your defenses, that you have to prove in order to win. Discovery can help you with that, too. And third, if you have any counterclaims, again, you will use discovery to look into them. I will warn you that this part of the case can involve some work. Yikes, right? Sorry, but this is a good time to invest some energy and time in the case. It will help you understand everything that comes later much better. In our hypothetical case, presented in our members-only video series on answering the petition, we are being sued in very general terms. It says, for money owed. So it could be for breach of contract or under theories of account stated, money had and received, or open account. And I randomly chose Arizona as our home state and researched to the issues under Arizona law. It took me 2 hours to find everything that I needed by computer search. It would have been much easier in a law library, though. In a law library, you just look in your state law digest under the theories mentioned. They're indexed. Would have taken less than half an hour. That's what you should do if you can. But I did it with a computer search using Google, and you can too. Finding the parts of breach of contract was a piece of cake. I entered my search for Arizona, breach of contract, and prima facie case. Got a few cases and read them. Until I came to the part of one of the decisions which said, to prove a claim of breach of contract, the plaintiff must show, and then it mentioned the aspects of the claim that a plaintiff has to show to prove breach of contract. And the good news is that the breach of contract is by far the most common claim brought by debt collectors, and so it is the easiest to research. Plaintiffs have to show a contract, its breach, that is, you violated the terms of the contract, and damages. And damages are obvious, the money you supposedly borrowed and failed to repay. How much the debt collector paid for the debt is actually irrelevant, that is, doesn't make any difference, since they're suing in the place of the original creditor that paid full value. They get to do that because they were assigned the debt, and they got all the rights to it. If they did get all the rights, then you could ask about that. But you can also ask and push for the information about how much they paid, claiming it is a measure of the debt collector's damages, or again, that it's part of the proof of whether the debt collector bought the debt. That may win sometimes. A lot of pro se defendants claim that it has for them. The debt collectors never have the contract, and thus they're always looking for ways past that problem. And that's why they often bring their claims under more than one theory. Their current favorite seems to be for account stated. To get the elements of that claim, I entered my search, Arizona, account stated, and prima facie case. And I did get a lot of cases, but I couldn't find one actually stating the elements of the case. So finally I tried Arizona, account stated, and elements, and looked up many cases that came up with that search until I found the one that I needed. That took a long time. There are lots of cases that would work. For some reason Google couldn't find many of them or didn't list them near the top of the search. That's why it took so long. It could be different in your jurisdiction than it was in Arizona. I'll include the results of my research in our document banks on my site. And after doing that, I did similar searches under the other laws or theories that I mentioned above. And in the end, I knew everything that the debt collectors needed in order to prove all their claims. Since we're bringing a counterclaim, we need to know what to prove for that, too. The prima facie case, and that is the things that you have to prove in order to establish your claim. The prima facie case for FDCPA violations is very simple. Did the debt collector do something which was deceptive or unfair? If your FDCPA claim is based on the petition they filed against you, and I often talk about bogus notices or false affidavits, there's really no need for discovery on that. The corporation is responsible for its lawyer. You don't have to prove that they knew what they were doing, but you can prove that because there's a statutory penalty a judge can award based on the degree of wrongdoing by the company. And that's really lucky because it means that you can ask some very interesting questions. Like how many people they've sued where they included the false affidavit or bogus notice or whatever the offending stuff is. And how many of these cases have resulted in defaults. You can also ask them for the names of those cases and all the people that they sued. And you don't have to restrict your questions to the local area. It's a national issue. So you're going to argue that they knew that they were fooling people. And in order to do that, you may need to interview some of the people who were fooled to prove that, reasonable people could be fooled. And then another question you might ask is, when did they start using the offending tactic? And who decided to use it? Whose great idea was it? Debt collectors totally hate to answer questions like that. And they will fight you tooth and nail to avoid answering them. But you should win eventually, and if you do, they will probably drop the case against you. For other types of FDCPA claims, and for other claims against a debt collector in general, you will need to prove some level of corporate responsibility. That is, you have to prove that someone from the company did it. It helps to get them to tell you how many times they did it to you, and, remember those statutory penalties? How many times they did it to other people too. Establishing the size of the penalty is why we put some of the discovery questions that we do in the forms that come with our litigation manual. Debt collectors can reduce or avoid the penalty if they can show strong systematic efforts to avoid violating the FDCPA, and that's why we put questions about that in the materials. Again, they hate questions like this, and they'll fight you as hard as they can to avoid answering them. You should welcome that fight. Remember that one main goal in this litigation is for you to show them that the lawsuit against you will cost them more than it's worth. How can you do that if they don't fight? And how can they fight if they don't fight you? No, you'll want to push the envelope on discovery so that they do fight. We created our membership program to help take some of the drudgery and guesswork out of waging this fight with the debt collectors over discovery. But you'll also want to win that fight at least pretty often, so that's why we did the research. The fight opens the way to a quick win and keeps them watching the clock as their profits drain away. In our next video, we'll begin looking particularly at interrogatories. Then we'll do the request for production and finally the requests for admission. You can do the actual discovery in any order you prefer and serve them either together or separately. You may not consider this video or anything I say in this or any video as legal advice. I cannot give you legal advice, but as a former lawyer I do know the legal process and debt law very well. So use what I say as a source of information and apply your own judgment to your case.